The next point for discussion is on Section 3 itself of the Right to Information Act. And the point of discussion is whether citizens, while seeking information under the Right to Information Act, must give proof of their citizenship. This is important from the point that there could be times when the public information officer may be suspicious about who the applicant is and may want to insist on the proof of the citizenship as well. This could be particularly important in places like the Northeast or in places like Goa, where the public information officers are really keen to understand who is seeking this information and whether he should entertain the application, process the application and provide the information, because the right to information is exclusively provided not only to persons but only to citizens. In case of this Narottam Sharma versus Guru Tej Bahadur hospital case, this is a case decided by the Central Information Commission in 2013, and this Hira Lal versus Estate Office, a case decided in 2006, the Commission has consistently held that the proof of citizenship is not a rule. It must not be insisted in every case. However, if, of course, there is a suspicion of a possible fraud through forged signatures, of course, committing a fraud or putting forged signature is a criminal offense. But if such suspicion raises, then the information cannot be supplied, and it would be legitimate for the CPIO to seek a proof or some ID from the applicant as well. However, the Commission has warned that this is not to be done as a routine case, and this would be done only in the case of any evidence that could be required, and the suspicion of the PIO should be recorded, and then he could go about seeking some kind of evidence of citizenship from the applicant. And now, as you are well aware of, in India, there are multiple documents that can go to prove your citizenship, right? The Aadhaar card could be one, the passport could be another. There are multiple such other documents which provide proof. As in the instance case, I think one of them could be sufficient for the citizen making an application under the Right to Information Act and seeking the same. So, proof of citizenship is not required. However, if there is a suspicion, it may be required. It may be something that is insisted upon. So, public authorities should not insist is what the Central Information Commission has consistently held. This is not a routine insistence. This is not a routine additional document to the application that must be submitted, and this should not be used to circumvent the right to information. This should not be used to create a hurdle to right to information. This should not be used to unnecessarily harass the citizens, right? So the CIC has said that and has also warned public information officers from misusing and seeking this proof of citizenship in every case. I think most public authorities did design an application form, and they expected that the applicant fill that form and file the RTA application. And I have noticed that in this form that was pre-printed, there was a column, "Are you a citizen of India?" You have to just declare yes or no, right? So some of the public authorities did insist upon the declaration by the citizen instead of seeking the proof of the same. However, I think citizenship under Section 3 or the proof that is required is only a procedural matter. Finally, if somebody wants information, he can ask or get that application filed by a citizen, and the public information officer will have to give that information. So to whom he is giving, I think the public information officer need not be much concerned about. I think the public information officer should be concerned about whether the information can be given or cannot be given. To whom it is to be given, I think that part has completely now been taken away under the Right to Information Act. Now, this position of mine is fortified by the fact that Section 6(2) of the Right to Information Act very clearly states that citizens need not give reasons for seeking information. So right to information is a right. It's a fundamental statutory right. And why you are seeking this information? What will you do with this information? I don't think the citizen has an obligation to state. So 6(2) very clearly says no reason need to be given for seeking information. right? You don't have to have any motive, you don't have to have any purpose, you probably don't have to be a victim, or you don't have to show your locus to seek that information. So whether the information is pertinent to you or not, you can still seek it. If you are actually concerned with the information or not, you can still go ahead and seek it. Now, prior to 2005, you will notice that in case we had to exercise the right to know as a constitutional right under Article 19(1)(a), you cannot file a writ petition unless you can prove a locus standi, right? So I think the locus standi principle under the Right to Information Act has been neutralized, and anybody can seek information of any other department, organization, of any other person. If that information can be provided and is not exempted, the same information shall be given under the Right to Information Act. I think the pertinent case on this is the Union Public Service Commission versus Dr. Mahesh Mangalat. This is a 2015 judgment, and the High Court very clearly said that under the Right to Information Act, the locus standi of the requester cannot be insisted upon. The locus standi of the requester cannot be something that can be asked or sought unless there is a larger public interest involved for the PIO to determine whether the information can be given. Because these are cases when we say that when there is an exemption to information and larger public interest has to be proved, then the citizen may have to give reasons why an exempted information should be disclosed. So when an exempted information is sought, reasons may be stated or justified. Based on that, the exempted information can be shared by the PIO. So when reasons are given for exempted information, it helps the public information officer to actually assess whether there is a public interest and is there some kind of compelling reason to share an exempted information. So those are the only time in which under the Right to Information Act can somebody state reasons, or can the PIO seek those reasons as well. So very clearly, normal application, citizen need not give reasons for seeking information. That is very important, and you will notice that when citizens need not state reasons, who it is does not matter. Whether the information can be shared or not is the only concern that the public information officer ought to take. Right. I think, friends, what we have done till now is to cover the definition of information, definition of citizen, and we have also looked at who can seek the information. That's what we have seen. It is only citizens of India who can get the right to information. The next point of discussion is Section 4 of the Right to Information Act. So after Section 2, which deals with the definitions, Section 3 that deals with citizens, now we move to Section 4, which is the duties or obligations of public authorities under the Right to Information Act. Now Section 4 is very, very important. It is important because the RTA Act is not only about the right of the citizen, it is also about the duties of the state. And the state is represented through this definition under the RTA Act called public authorities. What are their obligations under the RTA Act? What are they supposed to do? What are the directions? How should they implement the RTA Act? What measures and steps should they take? And please note, the consequences of violation of Section 4 are also important, and that we will come to in a little while. However, let me start listing the duties and the obligations of the public authorities as they were under the Right to Information Act. To be honest, when we say there is a right to know in a democratic system, and the right to know is to be exercised against the administration of the state, we always think that you have to apply for your right. And then it is the discretion of the state to either accept your application or not to accept your application. Correct? So you actually have to make a petition, you have to make an application, you have to make a requisition. So, generally rights have to be exercised is generally what we would want to say. However, if democracies have to stand for transparency, for openness, for accountability, even without being applied for, even without being asked for, then you will notice that Section 4 is an important section that casts a duty and an obligation on public authorities to disclose information even before it is asked for. That's the interesting part. So it is not about always the right to apply. Yes, that is definitely there. Citizens do have it. But it's about putting the information in the public domain even before it is asked for. So this is what we call as the proactive disclosure norm. under Section 4 that is very important in terms of what public authorities are supposed to do under the Right to Information Act. However, even before that can be achieved, I think Section 4 very clearly recognizes one important factor. And that factor is the success of Right to Information Act depends upon government's administrative functioning in what I call as record management. See, interestingly, no RTI is going to be successful if record management in government is weak, is not systematic, is not up to the mark. And hence, what is the duty of the public authority in terms of collection, maintenance of records? Now, we should know that record management in government is weak. It is a challenging factor, and most of the time that is spent in RTI is actually in terms of finding the record, in collecting the record and providing the information. So I think there is a lot of administrative process that is involved in record management, and unless the government invests in record management, there won't be efficient implementation of the Right to Information Act. So there is a clear interlink between record management, the administrative structure in an organization, to the Right to Information Act. And unless record management improves, Right to Information Act is not going to be meaningful. And hence, you will notice that Section 4 of the Right to Information Act provides for the following. It is the duty of every public authority, and the word used in Section 4 is shall. It's not about may, it's not an option, it's not a discretion. Every public authority shall maintain its records duly catalogued and indexed in a manner and the form which facilitates the right to information under this Act. Now, interestingly, record management is an art, it is a skill, it's a science. And unfortunately, most of our government offices are not trained in record management. And this is what actually delays or hinders the right to information. Now, duly cataloging and indexing of records is being insisted. And the mandate is that public authorities must implement the Public Records Act of 1993 effectively. Now, you will notice that the Public Records Act of 1993 is interlinked to the functioning of the Right to Information Act. And you will, in one module, go through the contents and details of the Public Record Act as it is implemented vis-a-vis the Right to Information Act. Cataloging and indexing of records. Why is it relevant? Why is it important? Because this will help you to actually not only keep the record in a scientific manner, but tomorrow, if after 5 years, if somebody files an RTI, it is easy to retrieve that information. It is easy to get the information and provide it. And hence, cataloging and indexing, generally found in library sciences, is something that has to be implemented in every public authority in terms of record management, is what Section 4(1)(a) actually facilitates, right? And this has to be ensured in a reasonable time. However, I think what Section 4 also insists about is computerization of the record. I think today, when records are kept in soft copy, in a computerized format, it's easy to retrieve, it is easy to find, it is easy to provide. And hence there is very less administrative cost in providing the information. Unfortunately, if you don't keep the record in computerized state, and if you keep it in hard copy, I think there is a high administrative cost in ensuring that the right to information is given to the citizens. However, Section 4 also says this is subject to availability of resources, which I don't think is a problem right now, but I think there is a caution of saying how much can be done by a public authority would depend upon how much budget or resources are in their domain so that they can implement it in a proper and a systematic manner. Why does computerization help? I think computerization also helps so that the access to such record is facilitated. And that is something that is being insisted under Section 4 of the Right to Information Act. If one continues to read Section 4, one would notice that it is the duty of the public authority to facilitate this information so that the citizens can actually easily comprehend the information, analyze the information, interpret the information, and probably use it to check accountability in governance. That is the process in which probably Section 4 wants agencies and public authorities to actually pursue that particular matter. You will also notice that it is the duty of the public authority to consistently look at developing certain manuals. Section 4(1)(b) prescribes a 17 set of manual that has to be prepared and put it in the public domain within the stipulated time. Right, so these are certain data on periodical basis that have to be provided. 17 sets. I will talk to you about what are those 17 sets of information that have to be disclosed upfront, and they have to be published in the public domain even before a citizen seeks for the same. And that data has to be periodically updated. So it's not one-time publication; it has to be yearly updated. And this is a function of the public authority, so that that information being available in the public domain, nobody has to apply for it. And that public domain includes both a domain in which people can access it physically, and people can actually manually probably access it through internet or through the website of the concerned public authority as well. So we will immediately come to what that is, but that is just a brief outline of what Section 4 has for us. Section 4.1c requires public authorities to publish all relevant facts on policy formulations within their domain. So policies that are generally the they are the earmark instruments for implementation of all schemes and decisions of a public authority. And hence, what are the facts that are relevant in policy formulation has to be also put out in the public domain, and that is what Section 4.1c actually mandates in these circumstances. Right? So it is the duty of the public authorities to notify to the citizens, these are the relevant facts, these are the relevant documents, these are the relevant parameters on which this department functions. This department provides this scheme, these facilities, these privileges, these licenses, these grants. So this has to be known to the citizen. Only when they know this, they can easily comply with it, apply for those licenses and get those licenses. This will cut the kind of bureaucracy hurdles that are often created in public authorities in India, and hence that is also insisted under Section 4.1c. Section 4.1d requires all public authorities to provide reasons for their administrative or quasi-judicial decisions. This is very important in the term of the fact that you do not expect public authorities to give decisions in an automation format. They're not to be operating as robots. So whenever administrative decisions are made, or whenever the public authorities act in a quasi-judicial role, right? When they are adjudicating disputes, they are adjudicating rights. A district collector will be actually adjudicating rights about compensation for land acquisition, right? So that's a quasi-judicial matter. An officer of the state may be passing an order against denial of a license for a restaurant. So that's an administrative process. Now, in all of these, it is important that one reads Section 4.1d. Now, the Right to Information Act interestingly brings about an attitudinal shift. It brings about a policy administrative change, and it says that whenever such decisions are taken by public authorities, they have to provide reasons. This is an administrative challenge that they have to comply with, and those reasons should be made available to the citizens under the Right to Information Act. So I can ask for those reasons. Rather, the reasons have to be put in public domain. Without reasons, no such action or decision should be taken, is what is the mandate under Section 4.1d. Now, in the case of Saroj versus Deputy Commissioner South, Municipal Corporation of Delhi, this was a case where the complainant stated that old age pension had not been paid to them. So the complainants were unfortunately aggrieved by the old age pension being denied to them by the Municipal Corporation of Delhi. And this was pending from 2007. So what they pleaded was, they pleaded that under Section 4 of the RTI Act, the Municipal Corporation of Delhi should provide detailed information of the pension scheme on their website. Who is entitled to the pension scheme? What are the people to whom this scheme is being provided? This has to be probably given on the website, is what was insisted by the complainant in this case. So the question before the commission was whether such pension schemes that are provided by different organizations of the government, should they be disclosed under Section 4? Should it be disclosed on the website before if it is being asked for? The commission directed to the Municipal Corporation of Delhi very clearly. They said this is a requirement of Section 4. This is one of the schemes that you are providing from your organization, and if you do not put it on your website, that's a clear-cut violation of Section 4. And you would notice that an amount of 1,000 was paid to the complainant as compensation, because these are people who are probably aged. They were keen to get information about who was getting this information? Why was it not published before so that they can access this very easily? So a compensation was paid to them because I think there was a denial of their right, and the public authority had not complied with the necessary requirement of proactive disclosure under Section 4. So proactive disclosure means when you are supposed to disclose, when there are certain information that you have to give, and the same has to be on your website. If the same is not provided for, then to that extent you will notice that the Central Information Commissioners will be tempted to impose penalties or pay compensation to the concerned applicants. To continue the discussion on Section 4, you will notice that every public authority shall maintain records, duly catalog and index them, and under this section there is a prerequisite that if we are looking at successful enforcement of this right, effective access should be provided for. So public authorities must be designed in such a manner that record inspection is facilitated. Public authorities must be designed in such a manner, or the record management should be such a manner that there is effective exercise of the right to information. So there is a clear command that public authorities, if they don't maintain their records scientifically, if public authorities fail in record management, that would also be considered as a violation of the Right to Information Act. The obligations of the public authorities are the following on Section 4. First, they ought to publish the requisite information within 120 days from the enactment of this law. And what they should publish are the following. So, the 17 sets of manual that I told you, what they should put it upfront or proactively are the following. First and the foremost, the particulars of the organization, functions and duties of various offices within that organization. Okay, so this is the first point. What does the organization do? What are its basic functions? And what are the duties and responsibilities assigned to different offices within that organization? So this is point number 1. Point number 2. Powers and duties of officers and employees. So this is point number 2. What are their powers? What are their duties? So that citizens know exactly who is responsible for what. 3. The procedure followed in decision making. So when a file or an application starts, does it start from the reception and whom does it go to finally before it has been granted or awarded for? So the procedure followed in the decision making process, the channel of supervision and accountability also has to be displayed on the website. So the organizational structure has to be very clearly set out. What are the norms set for discharging functions? So what are the norms for discharging the individual functions has to be also clarified. For example, probably you can say what is the timeline for on a file. What is the timeline to give a license or a grant or a privilege? So that norm for discharging their function must be very clearly stated. Suppose a file comes to me, within how many hours or days should I clear the file? Interestingly, rules, regulation, instructions, manuals, and records, all of these that are there within the control and used by employees for discharging their function must also be displayed. Now, there may be a lot of internal rules and regulations for officers to discharge their functions. Those have to be very clearly put out, right? So, the manuals for administration, the business conduct rules, all of these are something that has to be put upfront on the website of the organization. Next, a statement of the categories of the documents that are held by it or under its control. So, the category of documents are life records, records above 30 years, records 10 years and above, so on and so forth. So, the categorization of documents must be clearly displayed upon so that citizens very clearly know which document is characterized how, right? The categorization could also be classified information or unclassified information. The category of information will be probably exempted and those that will be disclosed as well. The next obligation is the particulars of any arrangement that exists for consultation, representation by the members of the public. So if there is any public consultation or representation process within an organization in terms of formulation of its policy or implementation thereof, that also has to be disclosed. This will help citizens to know whether they can make a representation to a public authority or not. And if there is a possibility of representation, how that representation can be made, when can it be entertained? That is something that can be known if this information is put up front. A statement of the boards, councils, committees, and other bodies consisting of 2 or more persons constituted as a part of the purpose of its advice. So most public authorities have certain advisory bodies, they have certain councils or committees that are constituted from time to time for the efficient functioning of that public authority. So if such boards, councils and committees are constituted in public authority, which has more than 2 or more members or persons, then those set of informations has to be displayed. Not only that, if there are meetings of such board, council and committees, then those meetings or the minutes of those meetings have to be made accessible to the public. So this has also to be disclosed from time to time. A directory of its officers and employees. This is important. So, who are the officers, who are employees, what are their category, group B, group C, those also have to be displayed. The next upfront proactive disclosure is the monthly remuneration received by each officer. Interestingly, this should include any other compensation that is provided by regulations to such officers. So what is the emolument of salary, compensation, perks that are received by employees or officers in that organization has to be also disclosed. And please note, this has to be updated. Now, unfortunately, when you scrutinize many public authorities' website, they are not updated. They are something that is published some 10 years back, or one time publication is something that, so whenever the salaries change or there is an increase, the same also has to be updated. So these are information that have to be updated every year or every time the information changes. The change has to be notified on the website. The next proactive disclosure is the budget allocated to each public authority. So how much do they receive from the government? What are their plans? What is the proposed expenditure? And any report on disbursement should also be made available to the citizen upfront. So this will clearly give an idea about how is the money or the public money that is being utilized in the public authority, what is their proposal, what is their plan, and probably citizens can check if there is misuse or abuse of the same plan, and they can notify to higher agencies if there are any discrepancies that are brought to the notice of such organizations. The manner of execution of subsidy programs, very important. I think subsidy programs that are offered by public authorities must also be put up front so that people know if they're entitled to such subsidy. If so, how should they apply? What are the documents that are required? So any kind of programs where there is a beneficiary that is to be distributed among citizens or among the concerned stakeholders, I think all these programs have to be disclosed. They have to be updated from time to time. And those are also set of information that should be provided under the Right to Information Act. Next is the particulars of recipient of concessions. So who has received what kind of concession, who has received what kind of permits, and who has received what kind of authorization. So, for example, the Pollution Control Board gives authorization to waste management companies to process, municipal waste, biomedical waste, electronic waste, or hazardous waste. If the Pollution Control Board has granted those authorizations must also be disclosed under the Right to Information Act on the website of that organization. This is very important. So permits. There could be interstate permits. There are permits for carrying out certain business activity, certain concessions that are awarded to certain category of individuals from the government from time to time. All of these informations that has been the function of a public authority also has to be notified. However, unfortunately, again, as I tell you, these are not so proactively disclosed by organizations. The next point is details in respect of information available, held, and reduced in an electronic form. This is directly in relation to the Right to Information Act, which means very clearly that it is the duty of the public authority to know how many applications have been received, what kind of information is being held by them, whether it is an information that is of the government or of a private organization, and how much of information is actually available in the electronic form, right? How much is information available in hard copy. Next, I think the particulars of facilities available to citizens to obtain information, including the working hours of the library or the reading room, if maintained for public use. Obviously, what can public access within a public authority must be disclosed as well. The names, designation, and other particulars of the PIOs. So, the name, designation, and particulars of the PIO must be published, not only in the website, but also somewhere very prominently on the physical space of the organization. So I think so people know whom should they contact, who is the liaison officer, what are the details, can he be contacted by email, by telephone, or should he be contacted physically. I think all this information should be easily made available, and if there is a change of the PIOs, I think the same change should be notified as well. Such other information as may be prescribed thereafter updated every year should also be part of the so these are so any other matters. So finally, a public authority may want to perform pretty well under the RTI regime. They want to probably do something more than what is prescribed in the above 16 parameters. They can do whatever they wish to do so. So that is something, or it could be something that is insisted by the Information Commission. So these are obligations of the public authorities. These are obligations for proactive disclosure under Section 4, and these are very, very important measures to the public authorities to take before they go about their business under the Right to Information Act. And hence the 17th set of requirements of manual of information must be upfrontly provided for. They should be updated every year, and this is a duty clearly on public authorities. So apart from the duties of public information officers, kindly know this is the collective responsibility of every individual working in a public authority, right?